All right, so sorry about the traditional lectern. I have to write and get my talk approved.
Our third speaker is from across the river, from the State Library, Daniel Flood. The State Library has been very innovative in terms of engaging in setting up makerspaces and 3D printing and various other things to enable its users to make and create and design all sorts of things. And the kind of library has played a very kind of key role in the maker movement in Brisbane and hosted a big maker festival earlier this year, in which the State Development Minister kind of announced new grants in relation to setting up maker spaces and fab spaces and technology hubs throughout Queensland. And so we're very kind of grateful for a library perspective from Friends of the
Thank you. So today's presentation will be full of pop cultural references. So Australia leads the way in illegal downloads of HBO's fantasy epic Game of Thrones. You can argue that this is a matter of access, that audiences today consume media on their terms and dislike being told when or how to watch it, or being locked into onerous contractual obligations to access the media they want to consume. Or alternatively, deep down, Australians don't care and they don't want to pay. It's not a matter of ownership of media so much as most services that they're accessing media through is either streaming, so Netflix, Amazon, Stan, or lease arrangements such as Apple iTunes, which means people never own the object anyway. It's his access and belief, rightly or wrongly held, that they as consumers have an inalienable right to access what and when they want. And it is a right that transcends legal implications, and if it takes criminal action to remedy through BitTorrents, Usenet servers, file sharing systems, amongst others, then so be it. Despite an active marketing campaign by both industry and government, vilifying and reminding everyone in the community. And these campaigns are not new in Australia. Campaigns such as Piracy, It's a Crime, and thank you campaigns have featured on commercial and rental DVD releases for more than 20 years now, and they have consistently addressed the impacts of piracy with a level of hyperbole. Home media has quite clearly highlighted the legal ramifications of said piracy with substantial fines and potential jail terms. So anecdotally, this has had limited impact on behaviour. The risk of apprehension for actions connected to media piracy is a distant possibility to the extent that they are mythical repercussions that don't apply to the average community member. It establishes the assumption that since no one gets caught, why shouldn't I do it? Like the Nike slogan says, just do it. So moving from physical media to an online context, aside from outright piracy, there is the grey area of circumventing geolocated restrictions on media using VPN technologies that are consistently evolving to meet new methodologies and emergent security solutions provided by big companies. These technologies are not being implemented just by the highly digitally literate community, but by the general public, in the belief, again, that it is their right to consume content at their discretion and not at that of the content providers. So industry builds the better lock and community builds a better key, which has been the trajectory of all security arms races throughout history. And the real reason why that a medieval lock design has little resemblance to a 21st century design beyond the core conceit that it locks things up. Software and hardware digital rights management systems, tracking IP addresses of offenders, HDCP, and the subsequent threat of legal action, blacklisting, and blocking websites connected to piracy are instances of these evolving solutions that have had varying degrees of impact, but they have not stopped offenders. And at times have just slowed the process, but in the end, it speeds up the acceleration of that metaphoric arms race. And it's this casual disregard of legality for content piracy that has been translated directly into other areas of intellectual property and its connective tissues to copyright, licensing and patents. And as the release of the domestic CD and DVD are, and later black and grey market software solutions for transcoding media and circumventing encoded digital rights management open the market for media piracy, so too has affordable 3D printing technologies. Given enough time, knowledge and the right tools, as with traditional media piracy, anyone can pirate a design, find a copy of an item that has already been created for the express purpose of 3D printing, or even an item for sale that has already been printed. Unlike the underground nature of media piracy, that requires software and an engagement with illicit platforms like Pirate Bay and so forth to implement. The latter two instances can be accessed through reputable platforms like Thingiverse, like Etsy. Take, for example, as brought up earlier, take, for example, the IKEA Lamp. Moulded plastic, comprised primarily of 90-degree angles, flat planes, and circular holes in the material. This bracket is part of a registered design sold by the Swedish furniture giant, and in this example, it is interchangeable for any other number of companies that deal in mass market flat pack furniture with plastic bits that tend to break. There is the argument that to replace the part is more labour intensive than simply buying a new lamp outright at $14.99. It is an argument that it can be countered by the limited resource and limited waste, wanting to recover from what we buy. So in any event, with access to Tinkercad, my favourite design platform of choice, or similar, a set of digital calipers and a 3D printer, you can resolve the broken part. It will not be as pretty as the injected moulded part. You'll see the striations of the fused deposition modelling, and it will not be as strong or as long-lived as the original, but it is a replacement. Part replaced, IKEA lamp saved, and a breach of intellectual property executed. Now, it's not a huge breach, and it's a breach that no one will ever likely be aware of, unless you write a blog post about it 5 years ago and post it on a government website that has a whole lot of traffic. The risk is minimal that anyone will pursue that breach, even if it's identified. And considering IKEA has allowed the continuing existence of websites such as lifehackers.net, it is unlikely they'll be upset that someone is fixing a lamp. But it is a breach. From IKEA, it's a small jump to conceptually car parts. That, of course, requires metal printing, which is a while away for domestic use, and other more high-value items than an IKEA lamp. These are created by enterprises that view intellectual property and the breaching thereof an entirely different proposition to a small piece of plastic. Breaching these intellectual properties is a moral and ethical consideration that a community member is unlikely to realise, or as stated earlier, care that they have committed. It's repairing something you own with technology you own. The assumption that this is permissible and fair use of a design that they have purchased, which they have not. They have purchased an object, an instance of the design, but not a license to reproduce that design. And while IKEA is unlikely to litigate, this should be a decision made as part of a risk mitigation strategy. It is not a guarantee, and it is safe to assert that the community does not know or have the tools to make those judgment calls at the moment. Because it all boils down to that risk. Acknowledging the risk and making decisions, understanding the potential consequence of that risk-taking behaviour. Australians every day make decisions to contravene legal expectations and place them at risk of a situation, but they undertake an informal risk audit when they make the call. Do I run the red light? Do I watch Game of Thrones illegally? This is no excuse for illegality, but it is a decision of the individual. It is conscious, it is a matter of conscience. And those decisions are outside the scope of this conversation to discuss. What is within the consideration of this conversation is the decision-making process and 3D printing, because it is frontier justice out there at the moment, and at worst it is a complete ignorance that is what should be considered by the community. I can, therefore I will. It reflects the comparatively small amount of time that this equipment has been domestically available, that there is a lack of consideration of reflection on the subject matter. It has been easier to get caught in the hyperbole of 3D printed guns and replacement body parts than immediate matters. There is also the thought that material can be accessed from reputable platforms, that it has to be legal, that the duty of care rests with the website and the user abdicates any sense of due diligence regards the material that can be found there. To that end, let us take the example of Mjolnir and Thor, the Norse god of thunder, his mighty hammer, Etsy and Thingiverse, and I promise you this will all make sense in the end. So the most complete record of Norse mythology is recognised as the Edda. It's an ancient collection of Norse folklore that has been translated into any number of times into any number of languages around the world. The collection is considered public domain, and its constituent material could be seen as open source sans an official licence. So no one can claim the actual concepts, but they do have claim to the distinct and discrete interpretations of that narrative. Most recent example would be Neil Gaiman's translation and reinterpretation of the Edda, simply titled Norse Mythology, published by Bloomsbury Publishing. He has taken the text, translated it into English, interpreted and added as he went to write a worldwide bestseller in his very British style. He has taken the open source and closed off his version of that narrative, and therein is his intellectual property. This is not the first time he has taken these characters, Odin, Thor and the like, and he reinterpreted them for a modern audience. American Gods was a very different telling of the character of Odin in Mr. Wednesday, which is now forever reminded as the character actor Ian McShane from Amazon's streaming limited series. In both instances, Neil Gaiman has the moral and intellectual property rights to these interpretations of Norse myth. Before these interpretations of Thor and Odin, he did it in a comic book series he's most famous for, The Sandman, which was created under a work-for-hire arrangement with DC Comics, which is a division of Warner Entertainment, and he has no intellectual control over those properties. Between those two instances, he created a work for Marvel Comics before Disney purchased them when Marvel went into Chapter 11, and this was called 1602, where he reimagined the Marvel superhero universe as if it was set in 1602. In that book, he worked with the Marvel character of Thor, originally written by Stan Lee in Venus issue 11, and realised in his iconic appearance by the great Jack Kirby, 100 years birthday yesterday, in issue 83 of Journey into Mystery, the 7-foot-tall blonde giant wielding Mjolnir and everything that comes with it, including Chris Hemsworth's performance in the Avengers, 2 Thor movies, and the upcoming Ragnarok. A long-standing established part of the Marvel lore for Thor is the phrase that comes with Mjolnir. Whoever holds this hammer, if he be worthy, shall possess the power of Thor. In more recent times, this is also taken in she, as well as he, but aside from those very aged gender values and a gross cultural misappropriation of mass media of a cultural narrative, this statement and the visual aspect of Mjolnir is the property of Marvel Entertainment, a division of Disney, a company known for its litigious protection of intellectual property. This 3D model can be found on Thingiverse, available under a Creative Commons Attribution Share-alike license, which does not acknowledge on that page any reference to Thor or Marvel because it cannot. It is a straight-up remix without license, it is a misappropriation of Marvel's intellectual property, and breach of copyright. From Etsy, you can have that hammer printed and shipped to Australia for less than $50, which we did for my partner's best friend's child's shower. They acknowledged the Creative Commons license back to the Thingiverse user, which is King Rahl, and are legally permitted to do printing under the terms of the Creative Commons license of King Rahl's design, but are now selling to the public an unlicensed product based on a Marvel Entertainment property, which is in turn, as I said before, a Disney Corporation property who have been known to take kindergartens to court for doing a song from The Lion King at a school presentation without license. So does Thingiverse user King Rahl understand that he is in breach of intellectual property law? Does Etsy user, decked out, realise that they are selling unlicensed Marvel product? The issue is not that they are engaging in a breach of intellectual property, is that they're likely doing it in ignorance of their action, or believing that they are exempt from being caught and maybe prosecuted, maybe not, or is it just that, again, they don't care? At least there is a clear transfer of license between these two parties. It is too common to see Creative Commons license being misused or abused, attribution not being provided, or even instances where commercial use of materials has been released under a Creative Commons license by a large entity such as Virgin, and the creators not realising they had released their rights, even though it has been heavily stated in their license that they had. This lack of understanding regards alternative rights management process, serves to complicate matters, and points to a lack of literacy in the general community. This is fundamental digital literacy concerns. Understanding IP and licensing, understanding how IP and licensing arrangements work are as important as how not to get scammed online and putting together a secure password for different websites. Part of every consideration around emergent technologies needs to include intellectual property and how it applies, preferably before there's a pogrom and the community at large are left saying that they weren't aware when in reality they possibly did not care enough to know, and ignorance is not a defence. is oftentimes it falls to places like libraries, such as State Library Queensland the Edge, to provide insight to the community at large, because ignorance is not a defence of the law and it is never going to be reasonable. That was a shameless plug. And over the past few days, if the estimates are correct, a number of people in this room enjoyed Game of Thrones Season 7 finale illegally. Not going to ask for a show of hands, but I just think it's an interesting thing to consider. Thank you for your time this afternoon.